go. Title issues and resolutions, part 1. And of course, as we usually do it, if you have questions, feel free to ask during the process. I do have time at the end if you want to wait as well, whatever's easiest for you. Sometimes it's easier to address it when it's related to the topic we're talking about, or sometimes you're waiting to see if I answer it, which either way is perfectly acceptable to me. Really flexible, so whatever works for you, but we will get started. All right, so today our overview and objectives are going to be to discuss common title issues for purchase and sales, and then what the resolutions are, and if there's any preventative measures that we can kind of circumvent this before we figure out there is a title issue. So for part 1, and this is what we're going to go through today, essentially, we're going to discuss unreleased deeds of trust, which you often see abbreviated as DOTs. We're going to discuss judgment liens, and then encroachments, as well as taxes. And then we're going to briefly touch on mechanics, liens, and contractor repairs. In a separate slideshow, and again, we can do this at our next CE, or we can figure out when to build it in, but the other commonly seen title issues are illegal subdivisions, estate issues. So that's when you have a decedent and there's an executor, or if there's no will, there's an administrator, or even list of heirs, all that stuff. Corporate entities, so LLCs, corporations, all that stuff. And then when there's bankruptcy involved. And this we might see a little more of, you know, with COVID and the die down, or having just debts that extend what the income is and not being able to pay those. And then random issues. So there's always that catch-all provision, right? But again, getting back to what we're going to go over today, and to give you the just fundamental baseline of what a title issue is, generally per the contract, sellers have to convey clear and marketable title. So what exactly is marketable title? Well, we have a case that defines it. It's free from liens or encumbrances, one which discloses no serious defects and is dependent for its validity upon no doubtful question of law or fact. One which will not expose the purchaser to the hazard of litigation or embarrass him in the peaceful enjoyment of the land. One which is reasonably well informed and a prudent person acting upon business principles and with full knowledge of the facts and their legal significance would be willing to accept with the assurance that he in turn could sell or mortgage the property at fair value. So again, I've highlighted the keywords because there's just a lot of legalese and language in there that probably distracts you from what it is, but it's truly free from liens and encumbrances. There's no serious defects that can't be fixed, will not expose the purchaser to litigation, and that the purchaser could sell or put a mortgage on the property at the fair value because liens aren't attached to it. That takes away from that value. So those are the big takeaways, right? That's how we're going to convey clear and marketable title. And more background. So generally the process is you have a contract, you know, seller gives, or the buyer gives it to the seller, they agree on the terms, they ratify the contract. Then the ratified contract comes to the settlement company. Once we receive that contract, we obviously do our internal processes of opening the file, but simultaneously with that, we have a licensed title examiner that goes to land records and does a title search. The title search goes back to about 40 years. That's if there's no title insurance policy involved. If there is a title insurance policy, which I'll touch on in a little bit, but if there is a title insurance policy, then we go back to that last title insurance policy. The reason why we do that is because title insurance essentially protects that there's no title blemishes or clouds on title from the point that that issue date was given on that policy backwards. So that's why we will do a title search from here up until the title policy, because the title policy protects all the way this way. So we don't need to then do double protection. So with that said, how do you do a title examine? Well, you search the seller's name. Sometimes they're indexed based on last name, first name, middle initial, or you can do a GPIN. Depending on the jurisdiction you're in, there's a GPIN. There is a tax ID, there's a map ID. It's just the distinguishing numbers that are going with that specific property and that short legal description. So that's how it kind of gets searched. It's all in land records. You go through and you have to pull deeds. If there's any judgments associated with it, we'll touch on it. All shows up in this title examination. From that title examination, then a title binder or a commitment, one and the same, just those both are used interchangeably, is formulated based on what the title examiner finds. A seller can perform their own search because this is all public record, but They're not required to. A title search will be done when you do sell your property. This is if really you just want to have a heads up on what might be associated with that. But it's definitely not a requirement at all. All right, so why do we care about this? Because again, the seller has the responsibility of conveying clear and marketable title. And if there's any blemishes on title that prevent them from going ahead and conveying clear and marketable title, then they're responsible for clearing that up. And they need to pay for the clearing up of those title defects. Again, anything that happened prior to their ownership can run with the land, meaning it's going to be the current seller's issue if it hasn't been cleared by the prior seller. So that's why you always want to purchase the property free and clear, so you don't inherit those headaches and then you need to deal with them when you are going around and turning to sell the property. So title insurance, again, a little more detail here, is a title insurance policy from a reputable title insurance company. We underwrite through Fidelity, which is the leading title insurer here. And it shifts liability from the homeowner to the title insurer. So if you have that title policy, provided there's no exceptions to it, then if any issues come up in terms of your title insurance will handle it. You do not need to worry about that headache. In most cases, the title company will pay for any claims against the property, again, provided there's no exclusions or exceptions, and it's a one-time cost. So unlike other insurances you hear about where you pay the annual premium, this is a one-time cost. You will not need to pay for it again. And when I say you, I mean in the homeowner, but you will not need to pay for it again, but it does extend with you throughout the ownership of your home. So if you think of a cost benefit analysis, it's really worthwhile. It's something I strongly encourage. And a lot of people are like, well, I don't want to pay that, or what's the point of getting that when you already do a title search? Well, here in the Commonwealth of Virginia, we have what's called a King's Grant. So way back when, the king would literally grant land to people. And there was no recording, there was no charting, there was no record of this. And so a lot of times you do have moments where people say, no, this land was passed down in my lineage. I got it from the King's Grant. Well, there's no way of proving that, but if you have a title insurance policy, then you can say, well, I was guaranteed I'm rightful owner here, title insurer, go ahead and deal with this. I have a claim on my property that someone says is theirs when it's really mine. You also see a lot of these in these upcoming title issues we're going to see. And if you have a title insurance policy, again, you don't need to worry about these headaches. But if you don't, then the burden's on you to go ahead and clear all these title issues, which could be expensive and can be time consuming. So again, it's a great thing to have. I strongly encourage it. It's not forced upon clients, though. It is an optional thing, so it's not a requirement. However, as a little caveat, if there's a lender involved, lenders absolutely will require their own title insurance policy. It is a requirement for a loan, and that is something the buyer pays for. There's no waiving it. So again, just to kind of add to the credibility of how important it is, since lenders require it, we should probably require it of our owners so they have that protection as well. With that said, we're going to go on to the first kind of big title issue we see, which are unreleased deeds of trust. So a deed of trust is also referred to as a mortgage, is also referred to as that security instrument. It's generally one of the longest numbered pages in the closing packet. And that is really what securitizes the lender's interest. That's what associates the lender with legal ownership of the property, right? So it's typically a previous homeowner's mortgage that was not released properly. That's what you see. So again, if you don't have that owner's title insurance policy, then you inherit the headache of needing to release that prior owner's deed of trust. If you have an owner's title insurance policy, then you just ask for that owner's title insurance policy, you hand it over and you're done. But again, if there's no title insurance policy, or if there's an exception to the owner's title insurance policy, then the lender will need to be contacted for a lien release process. And essentially what that is getting the lender to go ahead and file what's called a certificate of satisfaction. So it requires someone to draft that document, sign that document, get the original document to the court, and pay recording costs. And then the court needs to record that. So it's not something that's done immediately. Sometimes you see unreleased deeds of trust and you're hoping they can be resolved, in the next 2 or 3 days right before closing. And we'll find out a little later, sometimes these smaller lenders are no longer here. So you have this unreleased deed of trust for ABC lending. Well, You go to contact ABC Lending, ABC Lending is no longer in existence. So then you need to find out who purchased ABC Lending, and then you need to contact them. And then they have a different loan number than the one we have, because we only have ABC Lending's loan number. So it's a lot of back and forth. It might seem easy, but sometimes it could be a little complex. So this is where that owner's title insurance policy is immensely helpful. But anyway, so that I digress because we're going to touch on that in a little bit, but that is an unreleased deed of trust. So let's look at a little examples just to see how we can see how these play out in different scenarios. So here is our example A. Seller Sally is under contract to sell 100 Main Street. She purchased it in 2016. The title search, sorry, let me go back. What happened? There we go. All right, she purchased it in 2016. The title search comes back and there's an unreleased deed of trust from Wells Fargo in 2010. So we know it's from the prior owner. Her current mortgage is with Bank of America. So she purchased an owner's title insurance policy in 2016 when she purchased the home. Buyer Bob now wants to close ASAP. How do we solve this? Are there any suggestions here?
Lily, looks like you're unmuted, so maybe you could try.
And it's okay if there's not. So essentially, again, I'm really like pressing on how important owner's title insurance policies are, right? And here we see that there is one. So the buyer's title company can probably use the current owner's title insurance policy as long as the 2010 mortgage is not seen as an exception, right? Because the owner's title insurance policy protects from the date the policy is issued backwards. So it would protect from 2016 backward all the way through 2010. So that would be kind of the best answer here, right? Now here in this set of facts, it states that she did purchase an owner's title insurance policy. So there's our answer, but seller Sally now can't find her owner's title insurance policy. So here is kind of the catch to that. Fidelity, who we underwrite through, only holds on to their physical hard copies of their policies for 3 years. And then once that's done, they're not required to hold any policies. However, the burden and the onus and responsibility of holding on to that policy is on the homeowner. So I strongly encourage people to always hold on to that policy, even if they move away from the property, because this policy does retroactively protect you as long as you can furnish a copy of it. So my best suggestion and kind of best practice is if you get a hard copy, get an electronic copy as well. So you can always keep it in your email and just search it. Hard copies sometimes get lost. Hard copies sometimes get destroyed. But if it's in your email, you can't necessarily have a computer crash and you lose it, because we more often, have Gmail or Ymail or Yahoo or whatever may be the case, where it's, so to speak, on a cloud. So all you have to do is just search it and it should pop up. So that's kind of a big emphasis there for just everyone to make sure they're protected and have the most benefits of what that owner's title insurance policy is. But here, seller Sally can't find her owner's title insurance policy. So there's a couple of things we can go with this. One, we can try to find the settlement company that did the closing in 2016 to track down a copy of that owner's title insurance policy. But just like lenders sometimes going out of business, settlement companies sometimes go out of business. So if that's the case, or they didn't keep a copy of that policy, they're not required to, then essentially what we're going to have to do is contact some of the big underwriters here. So again, we underwrite through Fidelity. There's also Old Republic or Stewart, any other title company there, and see if they have the policy, because they might have it in their records. Or the other option would be, and we see here, so there's a little details, that the title search comes back and there's the unreleased deed of trust from Wells Fargo. So we know that Wells Fargo is the lender that did not release the deed of trust. We could then contact Wells Fargo directly and try to talk to their lien release department and say, hey, we need this certificate of satisfaction. We need the lien released. Now we know Wells Fargo is still in existence, so that should be relatively easy. Again, we run into some hiccups if it's ABC Lending and now they're no longer in existence. But that's example A. Let's go to example B. Seller Sally is under contract to sell 100 Main Street. She purchased the home in 2010. The title search comes back and there's an unreleased deed of trust from DiTech from 2015 when she refinanced. Her current mortgage was with Bank of America. She purchased an owner's title insurance policy in 2010, but it does not help with the refinance of 2015. Buyer Bob wants to close ASAP. How do we solve this? Now, before we go into a potential answer, if you see a bullet point here, she purchased an owner's title insurance policy in 2010, but it does not help with the refinance in 2015. That is true because, again, remember, an owner's title insurance policy covers from the date the policy was issued backwards. So it doesn't necessarily cover you forward except for fraudulent conveyances, which we can get into a whole nother day. But again, things can come after that title search occurs, right? And so they have no way of guaranteeing and protecting that if they don't know what can come in the future. Okay, back to how do we solve this? Any suggestions here? And as a hint, we kind of touched on this in our alternative options on example A.
No one's brave.
I was just gonna say, either I need to do a better job explaining things, or we have some shy people today.
I'll try. Would they be able to contact DiTech from 2015?
Bingo! Woo! Good job, Shelly. Yes, that's exactly the correct answer. So they'll need to contact DiTech and work with them to get that essentially lien release. And what it is, generally speaking, is you contact them. And when I say you, it's the seller settlement agent that's going to be doing this, but so that you have that complete, background, you would contact the lien release department and work with them to get a certificate of satisfaction. Exactly right, Shelly. All right, let's go to another example and then we'll move on. Seller Sally is under contract to sell 100 Main Street. She purchased the home in 2010. It was new construction. Title comes back and there's a $6 million deed of trust still attached to the property from the builder. Buyer Bob wants to close ASAP. How do we solve this?
The builder. Hi, this is Lily.
Hi. Yeah,
Hi.
you are right. You got all right. We're rocking and rolling now. We just had to warm up. The bill, that's correct. Now here, and this is just another little aspect of it. I'm imagining 100 Main Street is not $6 million. If it were, good on you, Seller Sally, but I'm imagining the $6 million deed of trust is probably for all the land the builder was developing. So here, we're going to want to get a partial release, and we're going to want to just release Seller Sally's new construction property. We don't want to get a whole release because we don't know, and that's not our responsibility, of where the other money may be going. Now, again, with the caveat, if Seller Sally's property is $6 million and that deed of trust is specific to her, then we're going to want a full release. But usually when you do have builders involved, they have a deed of trust for all the land, and then they build the houses on the land. So we just want it for Seller Sally's house. But yeah, we are good. All right, so now we're going to move on to judgment liens. Generally, if someone does not pay a debt per a contract, then the creditor can file a judgment lien against the debtor and record it where the real property is located. The debt attaches to real property, causing a title issue. Often what you see is credit card, medical, HOA, and then child support, personal injury judgments, stuff like that. Now, I don't know if you've heard, I think starting effective July of 2022, there is talk, and it's true, but medical debt will not affect your credit report, meaning it will not show up on your credit report. Now, there is some confusion with that. That does not mean they still can't issue a lien against the property. So this is like two different things here. It may help a buyer, right? Because their credit score may be a little higher, so they may not look as much of a risk for lenders, which is awesome. But again, from a real property standpoint, the medical provider can still go to collections, can still try to pursue that debt. And if you fail to pay that debt, they can go ahead and issue a lien against the property to get that debt once the property is sold. So I just want to kind of clarify that if you've heard of anything. But these are the common judgment liens we'll see. So let's go into some examples to see how this can play out. Seller Sally S. Smith is under contract to sell 1100 Atlantic Avenue. Title comes back and there's 3 medical judgments from Centera that may be attached to the property. She claims they are not hers. However, she does remember an ER visit at Sentara Hospital 10 years ago, but she thought she had paid all the bills. One of the judgments is for Sally S. Smith, so matches her name. And then 2 of the judgments are for Sally Q. Smithson. How can this get resolved? Any questions about this one? Because this is missing a little detail. I wanted to see if people have seen this in their experiences or if they have suggestions.
I think,
yes.
I'm sorry to interrupt.
No, you're fine.
I think that the judgment for Sally S. Smith, since it matches her name, needs to be investigated, and she's, she should contact the hospital to find out, contact the finance department to find out if that debt has been cleared or not. And if it hasn't been cleared, then she would have to clear that debt in order to release the lien.
Bingo. Yes, absolutely correct. So for the Sally S. Smith, like you said, because it matches her name, it needs to be investigated further. So we need to make sure, and generally on judgment abstracts, it will have the last 4 of the social security number of the person the judgment's against. So we'll get the judgment abstract, we'll see the social security number, and if it matches our client, Sally S. Smith, with the social security number on that judgment, then it's the same Sally S. Smith. And at that regard, then we're going to need to get a payoff, and we're going to have to pay it off before we can sell the property. And generally you'll see payoffs on judgments just being, on the HUD or on the CD and Alta, it'll just be a deduction, kind of like a payoff for a mortgage. It's reducing what the net proceeds are that the seller could be entitled to. So absolutely right for the Sally S. Smith. Now, Sally Q. Smithson, this name is like very different from our client. So we'll just have her sign a judgment affidavit. A judgment affidavit is a document that the person signing it is attesting under oath, stating that this is true. And the judgment affidavit states, I'm not that same person listed in this judgment. I'm Sally S. Smith. I'm not Sally Q. Smithson, nor have I ever been. And in terms of this, these judgments are 10 years old. Statute of limitations for judgments, when they attach, is 20 years per statute. So judgments are good for 20 years. Now, if nothing is done, the judgment is essentially unenforceable after 20 years. However, creditors have the right to renew the judgment for another 10 years if they do it prior to the 20 years expiring. So that is kind of just food for thought in terms of how old a judgment is. Some people roll the dice and say, hey, I have a judgment that's 19 years. I know this. I'm going to wait 1 more year. And if it's not renewed, then I can sell my house. Some people have no idea judgments have attached. A lot of people are like, I never got notice of that. How do I know that? Like, yeah, that's me, but that's not fair. I would have paid it, all this stuff. And when you have a client that struggles with, well, yeah, but I'm not going to pay that, but people are responsible for their debts. They pay their mortgage on their house, right? They pay their gas, they pay bills. And even though you didn't know about it, it's still a bill of yours. And unfortunately, it's still a responsibility, right? And it's going to be associated with that property. So unless you want to retain us to negotiate to see if we can get a lower payoff amount or something like that, it's going to be part of the property. There's nothing we can do about it. It's just a title defect, unfortunately. All right, let's do an example B.
I have a question before you go to the example. Although the judgment is not enforceable, does it automatically fall off as far as the lien that they have on there, on the title?
So it probably wouldn't automatically fall off because it would still be associated with the property. But if it's after 20 years, it is unenforceable. So generally there would just be an indemnity agreement in the document stating that, if something ever came of it, the seller would indemnify the buyer. From a title insurance standpoint, not, and to get it truly released, you would need a release filed. All right. Judgment liens, example B. Seller Sally is under contract to sell 1100 Atlantic Avenue. She rented the property for the past year and the tenants just moved. Title comes back and there's an HOA lien on the property. Further, HOA dues are delinquent for the past few months. Clearly, the tenants were not paying the HOA dues. How can this be solved? So we'll see here, it does say HOA lien on the property. So it's a lien on the property, it's attached to the property. And regardless of in the contract, if the tenants were supposed to pay or not, the seller, so seller Sally, is the owner. The owner is responsible for the property. So essentially the owner, seller Sally, is going to have to get these paid off. So this is just kind of like a little related but non-related comment. When there are HOAs or condo associations involved in your transactions, a lot of times it's technically like HOA violations, condo association violations. Those aren't clouds on defect or title, because they're only violations. They're not liens. Now, if they go to liens, that's a cloud on title. But if there's violations, they could potentially turn into liens, depending on what the association is going to do. So I always encourage you guys to make sure you look at the resale disclosure and see if there's any violations that are noted. And if they are, you're going to want to either alert your client to, hey, this is potentially what you're coming into, or try to negotiate for them and say, hey, we want these violations, you know, repaired and approved and signed off by the HOA before we go ahead and inherit that headache. So that's, again, not something that has anything to do with title defects. So technically buyers don't need to go ahead and fix them because they're still conveying clear and marketable title. But if you have that advance notice that there is a violation and it's something that's easily fixable, or you can always negotiate the contract so that maybe they take a lesser sales price so that they can go ahead and, you know, pay the money for the painter to get the shutters up to the right color or whatever may be the violation. So food for thought. We can kind of go through that a little more in detail if you want, but I wanted to highlight that because we do see that from time to time. Violations that, pardon?
I do have a question regarding that.
Yes.
This morning, I actually was contacted by my seller who's selling his condo. And when the condominium received their resale package, they notified him and said that the front door is the wrong color. And he's like, well, the color's been this way for the past 6 years. And we're under contract right now. We're currently under contract. So who is liable for that? Is it the condominium? Is it my seller? Or do I negotiate with the buyer? So I guess there are a lot of different options here.
I mean, you, as a seller's agent, you don't need to negotiate with the buyer unless the buyer brings it up, right? Because that's something the buyer could potentially inherit as a problem. But again, as long as it's not a lien, they haven't, put a lien on the property for failure to comply with the rules and regulations and covenants, then it's just a violation of the association. And unless the buyer negotiates that with your client, then you don't need to fix it at all.
Okay, so it's something that needs to be negotiated at the end of the day, because it was something that was noted. When she went, the condo received their resale package, they went and inspected the property, and they noted that the door was not the correct color.
Yeah, I mean, we could definitely talk about that more since this is an active case. I don't want to go ahead. I mean, unless you're using us, I don't want to have to go ahead and go against someone you're using. So I would encourage you, if you're using us, I'd be happy to talk about it. But if you're using someone else, talk to your settlement agent to see how you would want to play that one out.
Okay, all right, thank you.
You're welcome. All right, next example. Seller Sally is under contract to sell 1100 Atlantic Avenue. Title comes back clear and they closed on October 1st, 2019. However, she had some financial difficulty that summer and was late on a credit card payment to Capital One. The new owners receive a judgment lien notice at the property on November 1st against seller Sally in favor of Capital One. How can this be resolved? So just because time is flying by, I'm going to provide us the answer on this one. Nothing needs to be done, and that's a great thing. So you'll notice they close on October 1st. The judgment doesn't attach until after they close on the property. So seller Sally is no longer owner, and then the judgment attaches. Well, the judgment can't attach to property that she no longer owns. So the judgment actually didn't attach to the property, specifically to 1100 Atlantic Avenue. Now, if seller Sally goes on and purchases another property, that judgment will automatically attach to the new property. So until the judgment is taken care of, that judgment follows the person to whatever real property they have here within that 20-year period of time, potentially 30-year period of time if they go ahead and renew the judgment for the 20 years is up. So we'll keep going. Oh, I have lots of judgment lien examples. All right, sellers Sam and Sally Smith are under contract to sell 1100 Atlantic Avenue. They initially took title as husband and wife, but they divorced 2 years ago and Sally has been living there and paying all expenses. No deed pursuant to divorce has been recorded. Title comes back and there's a credit card judgment from Capital One for Sam Smith from 1 year ago. So this is interesting because it gets to how people take title. If you're married and you're taking title as a married couple, you want to take as tenants by the entirety with rights to survivorship. That gives you the most protections against creditors. So essentially, if you're married and Sam had a judgment, well, the creditor couldn't attach to the property because it's tenants by the entirety by the married couple. However, upon divorcing, so we see they divorced 2 years ago, you become tenants in common. That tenant by the entirety protection severs. And it's automatic upon the enter of the decree of divorce. So then you become tenants in common. At that point in time, any judgment against any of the husband or the wife can attach to the property. So here, there is a judgment that came back from Capital One against Sam Smith for 1 year ago, but they divorced 2 years ago. So again, they divorced 2 years ago, became tenants in common, and his judgment attached to the property 1 year ago. Well, yep, that's true because they didn't do a deed pursuant to divorce to transfer ownership. So technically it's still both of their properties. They're just holding it in tenants in common. So that judgment against Sam has attached to the property. So unfortunately, it's going to have to be paid. Now they, being Sam and Sally, can go ahead and try to figure out, okay, it's going to be paid out of Sam's portion of the proceeds because it's Sam's post-divorce judgment. But he doesn't necessarily need to agree to anything because it's still his asset as well. So you can get into kind of a lot of negotiation, if you will, or debate or circling around to divorce attorneys or whatever may be the case in this situation. But unless you get a deed transferring ownership to one spouse or the other spouse upon a divorce, it's still both spouses' property, just tenants in common, not with that protection of tenants by the entirety. Right. Encroachments. So often we see encroachments in terms of a neighboring fence being on your yard. If there's a home that's part of, a building setback line and they're above or beyond that. If there's a driveway that goes onto your property line, if there's a shed sitting on top of a utility easement or something like that, or any other structures, a pool sometimes spills over into the neighboring yard, whatever may be the case. Encroachments are just things that aren't your property that are on your property. Essentially, they're encroaching on your property. Surveys often show encroachments. That's why, people are like, why do you need to get a survey? We already have a fence. We already have this. We already have that. Well, you don't need a survey. It's not a requirement at all, but it's good to know. If you want to put a pool in, is where you're planning on putting the pool going to go ahead and go right over a utility easement where eventually the utility company can come mow through your pool if they need to fix that utility easement. If there's a drainage easement that's often known to get backed up, you might not want to put a shed on it because your shed could get, flooded. They can require you to move the shed to go ahead and fix that drainage easement, stuff like that. It just saves you the headaches, or it makes you aware. Or if you're planning on putting a new fence in and you realize, oh, the fence that currently there is my neighbor's, but it's actually on our property. So I'm going to ask them to move it, or I'm just going to move it myself. It just gives you awareness, right? So let's look at examples here. Buyer Bob ratifies an offer to buy 100 Main Street. There are no fences in the backyard. Bob notices a decently sized shed towards the back of the lot that appears to be on the neighbor's property, but it's hard to be sure. How should this get resolved? And I kind of alluded to it, but order a survey, right? A survey shows property lines. So when you look at a survey, you see dark lines, and that's generally the property lines. You see dashes with X's, and those are fence lines. And then you see just dashed lines, and those show where easements are. So it gives you an idea of what you're working with. And it will show also structures. So this shed, right, it would show if it's sitting within his property line or if it's sitting outside his property line. And if there's no shed, then it means it's probably not on his property line because the survey is dealing specifically with a certain parcel of land. So, or a survey is the simple answer. Surveys generally run around they start at $400, I should say. depending on the acreage, depending on how hard it is to find. They have, you know, different anchor points, and that's flags and stuff like that. But more or less in the Commonwealth of Virginia, surveys are good for about 10 years. So if a prior owner has a survey and they give one to you, that's awesome. If it's older than 10 years and you're wanting to do something or just be knowledgeable, I would encourage probably a new one after 10 years. Just because sometimes easements occur for utility and drainage as new developments occur in older, you know, older homes are knocked down, new houses are built up. There's just different things that are changing all the time. All right, next example, buyer Bob ratifies an offer and buys 100 Main Street. His yard has a fence and the adjacent neighbors all have a fence. All the neighbors' fences end at different points. However, beyond his fence, there's a grassy area and a medium-sized pond. Bob is curious as to whether that land is his or not. How should this be resolved? So the answer is pretty easy, but just to give you kind of an idea, sometimes people don't build fences all the way out to their property lines. Sometimes they just build a fence where they want the fence because they don't want to pay for the material and the labor to put a fence. Sometimes their yard is just so big, they just want a fenced in area, and then they want to go ahead and have like a little nature preserve out back or something like that. That kind of this indicates. So he wants to know if that grassy area and medium-sized pond beyond the fence is his land. He orders a survey and he'll find out. He'll see where the fence line is compared to his property line. If this is the fence and this is the property line and this is where the grassy pond is, then it's absolutely his. If this is the property line and then here's the fence and pond, then it's not his. And that survey would show that. Buyer Bob ratifies an offer to buy 1100 Mill Swamp Road in Smithfield. It's a 5-acre parcel with a very little fencing. Bob is a horse enthusiast and needs every inch of the land for his horses. Buyer Bob notices neighbor Nancy's horse riding ring may be encroaching on his property towards the back of his lot, so he orders a survey. Sure enough, the survey shows the encroachment on the parcel by 20 feet, which is significant. Buyer Bob still wants the property without the encroachment. How can this be resolved? So if there is an encroachment, you get a survey, it shows the riding ring is encroaching or your neighbor's fence is on your yard, and I kind of hinted to this when I discussed the examples on the front end. But the best way to go about rectifying this is to going and knocking on your neighbor's door and saying, hey, I've gotten this survey done. I've noticed that your fence, your riding ring is encroaching. Is there any way you can move it? Can you get it off my property? And if they're giving you pushback, you can say, okay, well, then I encourage you to get a second opinion. However, my survey was just done. I will provide you a copy of it. And if this isn't done, then I'm going to have to potentially file a civil trespassing suit. It's not something that you should write yourself. So you shouldn't necessarily move it for them because that could be destruction of property and you don't want to get into that. So you would, as a best practice, go ahead, file a civil trespassing suit. And have a judge order the movement of that item. So be it a shed on your property, a horse riding ring on your property, a fence on your property, something like that. And a lot of times too, if a survey is getting done because your client wants a new fence and they realize, oh, the neighbor's fence is encroaching, they often go to the neighbor saying, hey, we're looking at getting a new fence. If you're okay with it, your fence is encroaching on our yard. What we're planning on doing is just having our company remove the fence altogether and put our fence up right on the property line. And neighbors more times than not are going to be like, oh, that's fine. And then they don't need to worry about it. They're getting a new fence. It's like a win-win for them, right? All right. Now we're moving on to taxes. Tax liens.
And actually, before we fully move on, do you mind, we had a question in the chat. I think Shelley had a question for you.
Yeah.
So going back to the tenants by entirety, when the deed is recorded that way, if a debt is individually the wife's or individually the husband's, it does not impact their property. Is that correct for that type of protection?
Yep, absolutely.
Okay.
The tenants by the entirety, is a protection for married couples. Only married couples can have that protection. And like you said, so they're married, they take title as tenants by the entirety, and then say they forget to pay their credit card and a judgment is associated with the wife. It will not attach to the property. If they sell the property as a married couple and they've never gotten divorced or anything, as long as they remain married, that judgment will still not attach. They
That's what I
will
wanted
need
to double check.
Yeah,
Okay.
no, you're correct. The one thing is they'll have to sign a continuous marriage affidavit. And again, affidavits are just, attesting under oath that what you're signing is true and accurate. But that's saying they've been continuously married from the day they took title to the day they're signing that document to show that there's been no break in that tenancy. But yep, it won't attach at all. You're right.
Okay, thank you.
You're welcome. All right, taxes. So these could be fun, especially when you have IRS tax liens. And that can be a process because we all are familiar with IRS being difficult to get a hold of on the phone and then they wanting their money, right? So two difficult things to deal with when likely there's going to be big IRS tax debts when there's liens associated with it. But you see sometimes judgments associated with city taxes that are delinquent or deferred. And if they're deferred, they still need to be collected before you can sell a house. And that is just part of being associated with the city where the house is, right? They know a lot with what's going on. So let's look at a couple of these that play out because again, with COVID, a lot of delinquencies occurred and a lot of forbearances occurred. And these are things that we're seeing more of as the houses are being sold now. So in an example here, we have seller Susie, who's under contract to sell 100 Main Street. Title comes back and there are $2,000 of delinquent taxes that need to be paid. Unfortunately, Susie was hoping to break even on the transaction before she heard about the taxes. How can this be resolved? So breaking even is essentially she's not going to make money. There's going to be no proceeds there. So it's not even like this $2,000 could be reduced from the proceeds. She'll essentially need to come up with the money. She'll have to bring the $2,000 to the table. And sometimes you say, my client just doesn't have the money. Well, part of the contract is that the seller is going to convey clear and marketable title. So it's tough, but she'll need to come up with the money or potentially be in breach of the contract because she has contracted by the settlement date to convey clear and marketable title. Now, there are 10-day built-in automatic extension windows unless you determine a different number for title issues and title defects. This would fall under that 10-day extension because there's a title defect of these delinquent taxes that have to be cleared. So she has that additional 10 days. And people are like, well, where does she do it? I mean, it's a joke, but scrounge for couch money. Ask for a personal loan from a family member with an interest-free payback period. Sometimes the buyers will be understanding and say, hey, we don't need to move in immediately. Let's close in 5 weeks. That'll give you time to, put money aside. But this is something that is helpful to kind of know on the front end as an agent, so you can try to prepare your client. But oftentimes clients are embarrassed about not paying taxes or not wanting to be forthcoming about that and hoping it's not going to, post on the city website or something like that. So it's hard to anticipate for these, but again, yeah, essentially you're contracting to convey clear and marketable title at settlement date, and having this blemish on title is not conveying clear and marketable title. So breach of contract, unless you're, again, having that understanding buyer who goes, that's fine, I'm just going to move on, clear it up before you put the market on or house on the market again or something like that. But it's part 7C of the RAIN contract. All right, another example. Seller Susie is under contract to sell 100 Main Street. She's elderly and has filed for exempt deferred status with the city in 2016. What, if anything, needs to be done? So I kind of touched on that. Even if they're deferred, they're still due at the time of selling, right? So deferred taxes are going to have to be paid. Now, deferred taxes are different than exempt taxes. Deferred are just deferring it to a different date, deferring it to when the property is being sold. Exempt essentially is something that needs to be approved by the city. You need to apply for it and it needs to be approved. But if you're exempt, you don't need to pay the taxes. And you could be partially exempt, you could be 100% exempt. There's different levels of exemptions. And likely when you see this is from an elderly standpoint or a military standpoint. We're heavily military here, and some military service members are exempt. They are very aware if they are. It is a process where you need to go to the clerk's court, or sorry, listen to me, clerk's court, the clerk's office in the circuit court to go ahead and file for that exemption and get that process. But that's on the responsibility of the homeowner. They need to do that. And it's after they close on the house, because you have to be owner of the house before you can file for the exempt status. All right. Buyer Betsy is currently renting a nice high-rise condo in town center. She is now under contract on 100 Main Street to purchase. She owns her own business and has made great salary the past few years. Unfortunately, she owes the IRS about $20,000 in taxes and they filed a tax lien. What, if anything, needs to be done so she can close on the home? So you kind of have to put a couple of things together from what we talked about for this answer. But right now, the IRS lien is not going to attach because she's only renting. She doesn't own property, right? Liens attached to property you own. So she'll purchase this 100 Main Street and it'll be fine. There's no liens or anything like that. She'll purchase it. And as soon as she purchases it, that IRS lien will attach. So then when she goes to sell 100 Main Street, she'll have to pay that IRS lien, right? It attaches to property you own. And at the time the IRS lien was filed, she didn't own any property. So it's just kind of floating around there waiting to attach to something. So hopefully that kind of clears that up. Sometimes though, if there's a lender involved and they realize that there's this lien floating around, they're going to count it as a debt and it's going to affect the debt to income ratio. And so sometimes lenders will require it be paid off before they go ahead with the purchase of a property. Or if they know that there's going to be something attached to their asset right away, they may require. It's lender specific though. I can't speak that it's absolutely a requirement, but something just to be aware of. If you have advance notice of that, it may be something that does need to be dealt with on the front end rather than when it does actually can legally attach. And then we're going to just briefly touch on mechanics liens. And this could, in essence, be a whole nother CE really, but contractor work and mechanics liens. A general contractor or any other lien claimant under section 43-7, 43-9 in order to perfect the lien given by section 43-3, provided such a lien has not been barred by section 43-4.01, shall file a memorandum of lien at any time after the work has commenced or material furnished. So work commenced or material furnished, but not later than 90 days from the last day of the month in which the last performs labor or furnishes material. So they have 3 months after the last day of the month. So last day of the month. So say they finished May 19th. They have until the last day of May, 90 days from that period of time, in which the building, structure, or railroad is completed or the work thereon is otherwise terminated. So there is a time frame that this has to occur. If they go beyond the time frame, then they can't attach a mechanics lien. But it is 3 months from the last day of the month. So often when you're selling property, you always see people that have to attest in the last 123 days, in the last 122 days. And there is wiggle room because again, it's the last day of the month of when the work was completed. So there is that wiggle room there. But that is affirming that no outstanding work's done, meaning no mechanics liens can be filed. All right. The main points here are if there is permits or building and stuff, you're always going to want an MLA, which is a mechanics lien agent designated on the building permit. That means anyone who has claims is going to go ahead and send it to the mechanics lien agent. If the mechanics lien agent hasn't gotten anything, then they can sign off saying that there's no mechanics liens. But if no building permit, then no mechanics lien agent is required and contractors can begin work without any notice. Timing is critical in all of this. Like I said, there's that deadline. It's 90 days after the last day of the month when the work was done. And then notice must be given to the mechanics lien agent within 30 days after the contractor begins work if the contractor wants to preserve its right to lien for all the labor and material furnished. So mechanics lien has to receive notice. Again, that's if the mechanics lien receives no notice, then they can just sign off saying that there's not going to be any mechanics liens. It's on the building permit. The building permit is affixed to the structure. So everyone essentially has notice of who the mechanics lien is. They can't say, oh, I never knew about that because it's clear as day on that building permit. All right. All contractors must file mechanics lien in land records within 90 days of the last supply of labor or material. So we kind of clarify that though, it's 90 days of the last of the month when that last of labors or materials was supplied. And it's not later than 90 days from the last day of the month. So again, that big threshold there is the 90-day deadline. If you go beyond that, you've waived your right to file that mechanics lien. Most due dates will be at the end of the month again, because it's at the end of the month. So it's not from when the end of work occurred. It's from the end of work occurring, and then we go to the end of that month, and that's when the 90 days starts. All right. Privity of contract must be with owner of the home. So there needs to be a contract between the contractor and the owner of the home. It's not like a subcontractor situation. And mechanics liens do have high lien priority in Virginia. So it's important that contractors get paid so that work can keep occurring and all that stuff. And they do survive property transfers. So again, the new owner of the property wants to make sure that's cleared up and handled because they don't want to inherit that headache. Now, we require affidavits from sellers when work has been performed 120 days prior to closing. That's why we always get that affidavit, trying to get to the fact that no work has been performed within that 123-day period of time. But if work has been done, then we need a list of the outstanding work, the amount due, copies of the invoices, and there's a lot of additional things. So it doesn't necessarily halt the transaction, but we need proof that these people are going to be paid, or we have to hold that money in escrow to ensure payment so no lien attaches for the buyer side. And we'll do a quick example here. Seller Sally has owned her home for 10 years. She bought it for $200,000, but is selling for $500,000. She's put around $150,000 of upgrades during that time. 6 months ago, her sunroom addition was completed. No other work has been performed since. Does she have any issues with potential mechanics liens at this point? And Christy's shaking her head, no, that's correct. Because again, I've really emphasized it, but it's a 90-day deadline, right? This is 6 months. So we're well beyond that 90 days. They haven't filed any mechanics liens. She has no issues. All right. Seller Sally bought her home for $100,000 in August of 2019. She put around $50,000 in upgrades by hiring contractors to help out. She has a building permit and listed hanger law as an MLA. They finished their work on September 15th and has proof of payment to all contractors and subs. In October 2019, she has it under contract for $200,000. Does she have any potential mechanics lien? So arguably she should have no issue because while the work was done in September, she has proof that all contractors and subs were paid. So mechanics liens only attach when there's an issue with payment and payment hasn't been received by those contracts or subs. So she has proof. Now, if someone did attach a lien, a mechanics lien to the property, she would probably just have to furnish proof of payment and a cleared check, and then it would just be dismissed. All right, and then seller Sally bought her home for $100,000 in August 2019. She has a building. Is this the one we just did? Oh no, okay. Roofer starts work on September 1st and gave notice to hanger law on September 1st. So mechanic liens agent received notice, right? Within the 30-day period of time of when they're required to give notice to mechanics lien agent. So good for the roofer. In October, she has it under contract for $200,000 with a closing date of October 31st. Sally has not provided proof of payment to the roofer. Does she have potential with mechanics lien at this point? So here she does have an issue because roofer starts work September 1st and provided notice within that 30-day period to the mechanics lien, right? Still has 90 days after the last date of the month of the last day of work he's done to file a mechanics lien. So here it doesn't even indicate the work's done, right? Arguably it's going to be done by October 31st, but that's still well within the 90 days he has to give notice. So yeah, she does have some exposure for a mechanics lien, especially because she hasn't provided proof that she paid the roofer yet. So he can go ahead and file something, right? Now, if a mechanics lien agent does state, hey, roofer was never paid, then it's our responsibility to make sure roofer is paid out of the proceeds so that he cannot go ahead and attach a mechanics lien. Because again, then that's an oopsie on the seller for not conveying clear and marketable title. And as a settlement agent, we need to protect against that. So we need to make sure the roofer is paid so that there's no lien that's going to be attached that then affects clear and marketable title. All right. And then last example here, seller Sally bought her home for $100,000 in January 2019. She has a building permit and listed hanger law as MLA. Roofer Ryan starts work on February 1st and gave notice to hanger law on February 1st. So within that 30-day period, excellent. Ryan completes work on March 1st and sends Sally the bill. By April 1st, Ryan has not been paid, so he files a memo of mechanics lien with the local clerk's office. Ryan gets busy and forgets about the bill. Seller Sally closes on the property on December 1st, 2019. Does she have any issues with the potential mechanics liens? So everything was done correctly up until a point, right? So roofer gave notice to the mechanics lien agent within that 30-day period of time, and then he filed a memo of a mechanics lien with the clerk's office. in land records within that 90-day period of time at the last of the month when the last work was done. So those are all good. However, then he forgets, right? So even though he gave notice correctly and filed the memo correctly, he waited too long to enforce it. There is a 6-month period of time that you have to enforce the lien. So he may have some other recourse, potentially under a breach of contract or something like that, but it wouldn't be a civil suit for a mechanics lien. So again, timing is hugely important. Now the burden is on the contractor for these mechanics liens, but again, there's that time frame, the wiggle room where they can go ahead and do it. So final thoughts here really are use a mechanics lien agent, and we would be happy to use a mechanics lien or serve as your mechanics lien agent, and get lien waivers when contractors are paid, so you know they're not going to go ahead and slap you with a lien. Proof of payment is always good, right? Because it's the best diffusion to a situation when someone claims you didn't do something. All right. Some takeaways. So title issues occur in literally about half of the deals. You'd be so surprised. And sometimes they're quick fixes. Sometimes they take a little more time. Every purchaser should really have an owner's title insurance policy. It is an optional thing, but I think if you've seen throughout these examples, having that policy just keeps the headache away from you and makes it a lot cleaner. And again, from the cost of it, it's pretty regulated. And the protection over time is just immeasurable, right? If you own your home for 10 years and you're paying $500, you take $500 over 10 years and it's minimal, right? And then generally buyers may release when sellers can't convey clear and marketable title, but there might be a dispute with earnest money deposit, right? Well, seller had the responsibility, and but for the seller not conveying it, we would have closed. So the buyer wants the EMD, but then seller feels like they had no idea that there was this defect, so they want the EMD, and sometimes that could be an issue. On purchases, obtain a title search as quickly as possible. Title searches are done literally as quickly as possible. Then it has to go to the underwriter, and the underwriter issues you a commitment. So there's kind of some steps. And then on listing, see if a seller is willing to pay for an owner search. Not a requirement, honestly. But sometimes if your owner is inheriting the property and has no idea, and they just want to know what they may, or they know that, you know, who they're inheriting from maybe had some medical bills and money wasn't the greatest with money, or maybe had a drug history. You never know, but sometimes family members know more than we know, but won't share. They just want to see what's there. So you can always pay for a title search. You don't need to be under contract to get a title search. It's around $280 to do a title search and get the title search to see what liens may be attached to the property. But that's the end. And we did great time. All right. Any questions? I know we kind of touched on some throughout, but if anyone saved them for the end, I'd be happy to answer questions now. Otherwise, you have my information. Feel free to give me a call. Again, I would love to earn your business. I would be happy to meet with you and kind of fine tune my services to your style, or just connect so that we can go ahead and work together to grow alongside each other, whatever may be the case. We are here for you. We're a resource for you. We want to see you thrive, and we want to thrive alongside you. So with that said, thank you so much. I'm glad it all worked out. And for next time, I think it's July, we will go ahead and do part 2 of this with the other common title issues we see.
Perfect. Thank you guys so much. Lindsay, thank you as always. That was great.
Absolutely. Good to see you all.
All right, bye.